We're not open yet.
Good morning. Apologies for the technical difficulties. We're going to get started in just a moment as people begin to enter the room. There we go. Good morning. Welcome to the Maryland Public Service Commission's administrative meeting for Wednesday, December 1st, 2021. Before we get started today, I'd like to announce the departure of one of our staff members. She's a regulatory economist that has worked with us in the Office of Energy Analysis and Planning for several years now. That is Nan Zhang. Nan's been a familiar face with us, participating in many dozens of administrative meetings. She will continue her career as an economist with another regulatory agency in the very near future, but I wish to thank Nan for all of her work and commitment to the PSC and to the state. Additionally, for those who are interested in our PC 44 docket, that's our docket with respect to grid modernization, you would be aware that recently, over the past 6 months, the Commission has set sail on initiating the last missing link piece of our grid modernization efforts, and that is with respect to distribution system planning. And I just learned within the past hour that the Commission has selected and announced that Silver Point Consulting will be the work group leader and facilitator of this very important work group. So for parties that are participating in the distribution system planning efforts, please note that Silver Point will be coming on board in the very near future to lead that effort going forward, and that is an important responsibility. With that, we have meeting minutes to approve from our last meeting on November 23rd, 2021. All in favor, please say aye.
Aye.
Any opposed? The meeting minutes are approved. Good morning, Mr. Secretary.
Morning, Mr. Chairman. There are 5 items on today's consent agenda. Item number 1 is an application from John Travis Forsyth for certification of a geothermal heating and cooling renewable energy facility. Item number 2 is an application from Black Rock Wind Force LLC for certification of a renewable energy facility. Item number 3 is an application from Wave Energy Services LLC to supply natural gas. Item number 4 consists of tariff revisions from IDT America Corp, reflecting changes in its intrastate access service. And finally, item number 5 is a notice from Atlantic Broadband Enterprise LLC of participation in a financial transaction.
Thank you. Do commissioners have questions on these consent agenda items? Commissioner O'Donnell.
Thank you, Mr. Chairman. I'm not sure who from staff will be handling item number 3 today. If you could identify. Ms. Zhang, how you doing? Good morning.
Good morning.
I just didn't get a chance. I tried to call to give a heads up, but wasn't able to reach anybody. So, but I do have questions. I guess the first question is a general question. In light of the fact that we denied this application previously, I believe. Is that right? Did we deny it?
Yes.
And Commissioner O'Donnell, if I may, can I ask counsel and the applicants to, if they're in the room, if they could please turn on their cameras and make an appearance. Right.
Hi, good morning, commissioners. Can you hear me? This is Alex Judd.
Oh, yes.
Good morning.
We could hear you, sir. Thank you. It looks like we have 2 other individuals.
Okay, great. Yep. Good morning. This is Alex. Yep. Chris Klemick along with me from Dave Pitney. And then we have Abe Freed, Wave Energy CEO, and Robert Blake, Wave's COO on the phone as well.
Thank you. Thank you. My apologies for the interruption. Commissioner O'Donnell.
Okay. Thank you, Mr. Chairman. I maybe want to talk to Mr. Blake. Mr. Blake, the buck sheet says that effectively, when you were at Zoom, you had nothing to do with Zoom's troubles with the commission, their regulatory distress. I'm paraphrasing, but that's effectively what it says. And how could that be if you were responsible for its operations? Mr. Blake, you're muted. We can't hear you.
You hear me now?
Yep.
Okay. The issue stemmed from an acquisition of a book of customers by Zoom. And the customers were put into our system and handled as all our rest of our customers were handled from a renewal standpoint. The operations team was unaware that this book of customers that we acquired from another company, the renewal terms were different than the renewal terms of our existing customers. And so they were renewed to a variable rate instead of a fixed rate per the contract. My understanding of the contract. And were given a choice. They could choose a fixed rate if they called in. So the operations team wasn't informed that of the renewal terms of this acquired book of customers who were entered into our system. And quite frankly, you know, I learning from this incident, I should have asked our legal department for a copy of the contracts of these acquired customers and review the contracts terms myself to understand if they're different than their renewal terms are different than our renewal terms. Our renewal terms in Zoom at the time, the renewal terms were most commonly used in the industry, and I didn't realize that these had sort of unique renewal terms that should have been handled differently. And I in hindsight, you know, I should have reviewed, got a copy of the contract and the legal term from these book of customers required. I should have reviewed them myself, and it was a learning experience.
So you were still the COO of Zoom when the investigation, show cause, and subsequent sanctions were issued by this commission. Is that not correct?
I was no longer the CEO when the sanctions were issued. I left when the case was ongoing.
I see.
I believe. Yeah, I didn't follow the case, you know, after I left, but so I'm not sure exactly the exact dates, but I don't recall being there. I was gone when the sanctions were issued, I'm pretty sure.
Okay, so
I
being the COO of Wave, give the commission some comfort that you're not gonna violate Maryland regulations again. We'll have to sanction Wave Energy under your leadership. It's troubling to me,
Yeah.
to be honest.
Sure, understood. So I've been in charge of operations in a senior position for a number of retail energy suppliers in Maryland, that operated in Maryland over 23 years. And under my leadership and the operations team, we've never had an issue in Maryland except for that one issue with Zoom. And that was when we acquired a book of customers. So it wasn't the normal operations of handling our customers. That was kind of a unique situation that we should have reviewed the documents. I should have got them from our legal department, reviewed them. So that was a mistake on my part. But when I was at MX Energy for 10 years running the operations, when I was running United Energy, when I was with Connective, very beginning of Connective in 98, subsequently and all the rest of Zoom never had any issues with its acquisition operations of its other customers in Maryland. And then other companies I worked for, we've never had any issues in my 23 years.
Would you agree with me that slamming a group of customers onto a variable rate in violation of the terms of their renewal agreement previously is a very serious matter in the state of Maryland?
But if Yeah, if they were slammed onto a variable rate, they were renewed onto a variable rate.
Yeah, well, my term, slam's
Yeah.
probably a pejorative term, but
Yeah.
they were
So
unwittingly
renewed with,
renewed with a variable rate at a time when it cost them a lot of money and ended up costing Zoom a lot of money.
understood. And
Would
like I
you
said,
agree that that's a serious matter or not?
it is a serious matter. I agree it's a serious matter. And in hindsight, I should have reviewed the terms and conditions of those customers that we acquired before we put them in a system, because we could have easily have handled them in our system, the renewal process differently if I was aware that they had different terms and conditions than our normally organically acquired customers.
Okay, Mr. Fried, I have a question for you, sir.
Yep.
What level of compliance operation do you have at Wave Energy established?
Um, the I sort of take care of the compliance together with Anna Fors, which is our compliance manager. We routinely check every rule and regulation that that does get established. Um, I'm convinced that the process and specifically on how we're going to be enroll customers, I believe really checks all the boxes of everything, and even above of that Comar suggests that we should abide by. So I
Doesn't
mean
suggest it, Comar demands it.
I'm sorry, Comar demands that we abide by, and I'm convinced that we have a contract with our TPV company, and the process is taken us a couple months to put together that I think is really gonna make sure that every customer knows that they're being enrolled, on what rate they're being enrolled, and everything is just going to be extremely transparent. And the process that we put together, I mean, I believe like Blake has more details on the process that he was supposed to talk about it, but that's a little bit why we we're going to be sticking to door-to-door sales. Uh, we feel that the TPV process, we're going to be getting, just to give you a brief overview, is we're going to be getting consent from the consumer after we say our sales pitch to send them a text message. And then this text message, the consumer is going to be receiving on their own device, and they could review. That text message is going to be a link to the contract that they could review at their own leisure. It could be done, then later that night or in a couple of days, and whenever they have the opportunity, they'll sign that. Once that's done, there's going to be automatically an additional layer of verification. There's going to be a TPV that's initiated. Once both of those are complete, I'm going to have my QC team validate the signatures, as well as validate an additional layer on the TPV call, and only then are we going to be submitting that. So we came up with that system. So we felt that it was much more compliant, and it would have been a lot easier for the customer to really understand what's going on if they can sign the contracts on their own device, and there's not really a rush with them sitting there with the door-to-door agent. They can really take their time to review everything.
So how do you ensure that your compliance manager and yourself communicate effectively to Mr. Blake the compliance mechanisms that you're talking about here? How are you going to make sure that the operations aren't disconnected, perhaps as they were in Zoom, with the compliance mechanisms?
Well, I mean, the contract and how we have it right now situated with our TPV company is we're not going to get access to that customer information to enroll them unless every single one of these steps are followed.
Yeah, but you're missing my question, sir, I think. So let me try it again. How are you going to make sure that Mr. Blake gets effective communications of your compliance efforts? Because he said he didn't know in the Zoom case, he didn't know what was going on with these new customers,
Right.
that their renewal terms had changed. How do you make sure your operations manager is in the loop?
May I speak to that? So Abe and I have been very closely working together to develop this process, and we'll continue to work together in the process. And I don't want to have it characterized that at Zoom I wasn't understand what's going on, because I was very much involved in the process of setting up when Zoom acquired its own customers through its sales process. And so I was very much involved in that process. It was only for this book of customers that were acquired, I wasn't aware of that one particular term, the renewal term. So I was very much involved in the process as a team, just like I'm very much involved in the process for Wave and our sales process. So, and we'll continue to be involved in the process because we have to set up the operation has to be in sync.
All right, last question for staff, and I'm not sure who in staff, but this is a consent agenda item for something that we previously denied and obviously had some significant concerns about, and I believe staff did as well. What has changed in the ensuing 4 or 5 months? What's changed here that makes me think our previous concerns weren't valid?
Good morning, Chairman, Commissioners. Nan Zhang, on behalf of staff. So this time, Wave Energy provided their business plan for the company, which they didn't supply last time.
Well, so they provided a plan, but does the plan assuage the concerns that we had, the basis for denial?
I believe last time the commission denied the license because of the issue with Zoom and the inadequate experience from the CEO. And this time they provided business plan, which pretty much covered the concerns the commission had last time.
Okay. Let me ask one more question, Mr. Chairman. I'm sorry to go on, but this matter is important to me, and I'm really surprised to find it on the consent agenda today, considering our previous action. Does Wave Energy understand, and I want it from the top, does Wave Energy understand the commission's new focus on compliance enforcement with regard to third-party suppliers? Are you fully aware of it? Do you know what we're doing in that regard? And are you prepared to operate in Maryland, should we grant this license, in a way that it's in full and 100% complete compliance with our statutory requirements and our regulatory requirements? Mr.
Yeah,
Fry.
I mean, we are aware of it. I mean, we've been following, you know, some of the cases lately that's been going on, which is essentially why we're, you know, keeping it extremely strict to, you know, one marketing method, which we feel a lot has what to do with it. A lot of what to do with the cases recently, from what I've seen, and we, you know, we sort of took the last couple months to secure and to make sure that the compliance process that we set up is going to really, you know, tackle a lot of the issues that, in our opinion, that have recently arisen to the commission.
All right.
So
Well,
we're definitely aware and willing to make sure that we will abide to all the regulations.
I hope so, and I hope the message is clear out there that the consumer protections are at the front of this commission's mind. These are not routine matters. Obtaining a license is not a routine matter in my mind. It's a matter of protecting the consumers in the state of Maryland, and we take that very seriously. So I hope the message goes out both to your company and to maybe a broader audience, that these matters are not insignificant. Thank you, Mr. Chairman.
Thank you. Commissioner Linton.
Chairman, and good morning, everyone. I had a question for the commission staff. In your review of Wave Energy's management and technical experience and competency, in your bug sheet, you primarily focused on Mr. Blake. So hypothetically, if Mr. Blake was not a member of Wave Energy's executive staff and was not on the staff at all, how would you characterize the remaining staff members of Wave Energy in terms of their expertise? And would you still recommend that they receive a license?
Yes, I believe so, because this time they provided a very detailed business plan to address the concerns the commission had last time.
Okay. All right. Thank you, Mr. Chairman. That's all I have.
Thank you, Commissioner. Mr. Judd, you did most of the representing at our last meeting in July. We spent the better part of an hour discussing the case. So I'll ask the same question Commissioner O'Donnell just asked. What has happened between July 7th and today that should make us more confident that your clients would be prepared to execute the functions of a retail energy supplier in the state?
Yeah, well, I think you heard it directly from Abe. We took that time. We heard what you said to develop what is a very comprehensive business plan, training materials, and contract to put it all out in front of you before you even acted on the license. And as staff has indicated, they reviewed it and determined it compliant to. We really wanted to come back and present our view to you to really understand the channel, the marketing method we would take, and how we would comply with COMAR and the public utility article. We were planning to do that anyways, and we wanted to put that up front as part of this meeting today. So that is the time that we took to really understand, have those discussions between Abe and Blake that you heard today, and put together that comprehensive material that we can start to implement if we get a grant of a license today.
Obviously, managerial competency is important in our review of these applications. I was concerned last time that Mr. Freed was relatively light in terms of being a energy executive, as he claimed. On the other hand, I don't think there's any dispute that Mr. Blake has quite a bit of experience in this field, although not all of that experience being positive. Mr. Blake, in hearing your responses to Commissioner O'Donnell, I can't quite understand if you are admitting culpability and taking responsibility for your actions at Zoom or not. So perhaps you could clarify and elaborate there. It did seem to me that you were trying to state that some of this may have occurred after your departure and that you didn't follow the regulatory proceedings after you left Zoom. So can you elaborate? Are you taking responsibility for what occurred at Zoom or not? Mr. Blake, you're on mute.
I guess what in hindsight, my responsibility is I should have asked the legal team for the contracts that these book of customers required from another company, and to understand that their renewal terms were different than our normal customers. And that's at the time I was the CEO, and the legal team handled the acquisition of this company, and we're just given the data to put into our system, and weren't. And in hindsight, I should have known. And so the issue, I view it as kind of like an internal communication within the company for this acquired book of customers, and I certainly was part of that internal communication failure, because I didn't proactively reach out to ask to review the contracts.
So you're accepting full responsibility. Is that what you're saying?
I'm not
Let's try to be clear here, Mr. Blake. I'm hearing some equivocation.
Yeah. So there's some responsibility I have for not proactively reviewing the contracts. I can't say that it was. So that my responsibility, the way I view it, is my responsibility that I didn't proactively ask for those contracts to review the terms of these acquired book of customers.
You stated a moment ago in response to Commissioner O'Donnell that you've worked in Maryland with respect to other companies. Can you list those companies that you work for?
Sure. I was with, initially I was with Connective Energy for about a year and a half. Then I moved towards, ran a small energy marketer called United Energy, owned by United Propane in Millersville, Maryland. And then in early 2000, I went to work for MX Energy, and I was in charge of their operations at MX Energy for 10 years. I was based in Columbia, Maryland. And MX had no problems. All those companies had no issues with the commission during all those years. MX Energy was eventually acquired by Constellation Energy. And at that point in time, I went to work for Zoom Energy. I was with them for about 5 years.
Okay. What about after Zoom?
And after Zoom, I went to work for Columbia Energy. Columbia had a number of regulatory issues, and they brought me on to fix their operations. They had a lot of operational issues that was causing regulatory issues in a number of states. They brought me on, and I went to clean up. I went there to clean up all their operations because I have extensive experience with operations. So all my operations experience over 23 years, there's never been any issues, regulatory issues with any of my operations over 23 years, except for the one case in Maryland. That was the only time there was ever an issue with any of my work in 23 years. I've always worked to follow all the regulations in all the states. In Maryland, I'm most familiar with because I've been in Maryland based in Maryland for 23 years. I was very much involved in a lot of the regulatory development of Comar early on, followed it, the changes, involved in a lot of the XML development for BG&E Gas and WGL. So I've been very much involved in the state of Maryland. It's where I have most of my experience, and never experienced any regulatory issues. And after Columbia, which is known as POMCO in Maryland, after POMCO, I went to work for Genie Energy. And with Genie Energy, I wasn't working in the States, but I was started and ran a retail energy company in Tokyo. And that's been my experience.
And you were the COO of Family Energy?
Family Energy, I was the CEO, correct.
Okay. Is there a reason why you didn't specify that work experience as CEO?
Well, Family Energy was it the Tokyo company? It was known as Family Energy in Tokyo, and in the U.S. it was known as POMCO.
Oh, okay, so POMCO has a lot of names. Let's talk about POMCO for a moment. You stated that there was no regulatory actions with respect to other companies that you work for, but isn't it true that the commission has taken a number of actions against POMCO?
Yeah, I'm not aware of the actions that when I was there. I went there to clean up their operations, and I brought a couple of people in with me, and we worked hard to clean up their operations and resolve the regulatory issues they had in some states. And so under my tenure there was never any new regulatory actions with the company.
But you were aware of complaints that were being filed against the company, correct?
Correct. And I was asked to join to clean up their operation and help them become compliant, which I did. So I didn't shy away from a company that was not being operated well. I went there specifically to help them clean up their operation and get them operating. And under my tenure there, we did not incur any new regulatory issues.
Mr. Judd, do you have anything else to add to this application before we take a vote today?
Yeah, the thing I'll say is just as a little bit of an outside observer in watching Abe and Bob interact and put together this additional material. I've been impressed. I, represent other competitive suppliers in the space too, and I think they've given a lot of thought and kind of foresight to what will be the best path for them in Maryland. And you've heard that today, and really, that they're ready and willing to comply with Comar and all the requirements and serve the customers in the state of Maryland if you grant a license today. So that would be all I would add to the discussion.
Thank you, Mr. Judd. We're just going to take a moment of recess here. Okay, the commission's ready to proceed. For the company, Mr. Freed, Mr. Blake, Mr. Judd, the commission is a licensing body with respect to the regulation of retail energy suppliers in this case. And part of that is to protect the customers, to make sure that the individuals getting involved in this business are competent and qualified to carry out and execute the responsibilities of a retail energy supplier in the state of Maryland. I personally have some reservations, both with respect to Mr. Blake and to Mr. Freed's ability to do so. However, that is balanced with the much more robust application and business plan that was filed after our last meeting on July 7th. However, because some of the concerns and the responses that I've heard today, I will be amending the motion to approve a license to Wave Energy Services with additional reporting requirements and conditions. To the extent that Wave does not agree to any of these additional reporting requirements, you should let us know now, Mr. Judd. And if you need an opportunity to confer with your clients, or if your clients want to speak for themselves, Mr. Freed could do so. So this is not our typical approval. The first requirement would be that if there's any changes to either your business plan or your enrollment processes, that you notify the commission within 30 days. And that should be an easy one. And I suspect that you would agree with that. So counsel, can you ask your client if he's amenable to that?
Yep.
Yeah.
That sounds amenable to me, Abe. Any concerns with that? I would say that's fine with us.
Yes, that's fine.
The second one is more substantive, but it's with respect to our attempts to protect the public and utility customers. And that would be that the company, Wave, file on a monthly basis a number and description of all complaints filed with the company. As you know, or as I hope you should know, that any complaints filed with the Commission's Consumer Affairs Division must first be filed and attempted to be resolved directly between the third-party supplier and the company. In effect, that means that many complaints are never brought to the Commission's attention because those complaints are resolved at the company level. What I propose here as a condition is that Wave be fully transparent and let us know on a monthly basis how many complaints are filed with the company directly. And if those complaints are not resolved to the customer's satisfaction, then they would have the opportunity to file a complaint with the Consumer Affairs Division. Mr. Judd, how does your client respond to that condition?
Just a point of clarification, Mr. Chairman, would this be, I would imagine, for a limited time period, not to go on forever if you're seeing no complaints, or, if you are satisfied? I think some kind of time limit would be acceptable, hopefully with the commissioners.
I would suggest, Mr. Judd, that it would be for an 18-month period after business operations resume. That will give us an opportunity to see if there are lots of complaints or if there's a trend developing. Of course, at any time, if say after 6 or 12 months we don't see that trend, your client could always petition the commission for a discontinuance of that condition.
Yeah, understood, and thank you for that. Abe, that is acceptable with me. Is that all right with you? Do you have any questions about that? This would be the number and description on a monthly basis of the complaints we receive.
Right. No, we're 100% willing to do that. I have no questions.
Yes. Okay. And that monthly compliance report would be filed with the director of the Consumer Affairs Division. Commissioner O'Donnell has a question.
Just so we understand, the chairman said 18 months, but the converse of, asking for relief from the reporting requirement would be that we could sua sponte extend that as well, should we not see adequate trends. So I just wanted to clarify that everybody understands that.
No, oops, sorry, go ahead.
No, Mr. Judd, yes.
No, I was just going to say, Mr. O'Donnell, I do appreciate that. And of course, that is understood.
But by the same token, if we see an increasing number over the course of 18 months of complaints being filed either directly with the company or with the commission reserves the right not only to extend that period, but also to revoke the license of Wave Energy Services. And so we will be keeping a very close eye on your company and the numbers going forward. Those compliance filings should be filed on or about the first of every month after business operations take effect.
Yeah, and can I just say something, which is we take this seriously too, and I know you're trying to put a check on us, and I do appreciate that. But I can tell you, if we see complaint, even if this requirement did not happen, we would want customers to be satisfied and to resolve complaints. So absolutely, we want that check. But just so you know, beyond that, we take this seriously as a company, as an ethos. In talking with Abe, so it's something we would obviously deal with in any event, and we're happy to provide that to the commission as well.
Thank you. At this time, I will propose that the commission grants Wave Energy Services LLC a license to operate as a natural gas supplier in Maryland for the customer classes and service territories applied for and recommended by staff. Direct Wave Energy Services LLC to provide marketing materials specific to its Maryland operations and both to commission staff and to the Office of People's Counsel 30 days prior to utilization of the materials in Maryland. Direct Wave Energy Services LLC to file notice with the commission within 30 days of any changes to the information in its application, in its business plan, or its enrollment processes. Direct Wave Energy Services LLC to report all complaints filed directly with Wave Energy Services LLC on a monthly basis to the Director of the Consumer Affairs Division, including the number of complaints and a description of each one of those complaints. That condition will be in effect for a period of 18 months, after which Wave Energy Services commences business operations. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton. Commissioner O'Donnell.
I vote aye, Mr. Chairman, but I'd like to explain my vote. It's not without some hesitation to approve this matter and overturn our previous decision. I do have concerns. I want my vote, though, to be heard with, although it's a yes, to be heard with some of that reservation, which is we're going to be watching very, very closely. And we do have as part of our Consumer Affairs Division, we do have a compliance enforcement unit. And that compliance enforcement unit may be checking on you. So all I got to say is I hope that things go well and that we don't have to see you again with regard to consumer protections in the state of Maryland.
Commissioner Richard. Aye. I vote aye. The motion is approved. With respect to item number 1, I move that we approve the application and issue a renewable energy facility certification number and energy savings estimate. Direct the applicant, Mr. John Travis Forsyth, to establish a REC account with PJM GATS within 30 days of certification and file a geothermal and thermal biomass generation report with the commission within 1 week of each recording of generation data with GATS of RECs created, and direct Mr. Forsyth to file notice with the commission within 30 days of any change to the information in his application. With respect to item number 2, I move that we approve the application and issue a renewable energy facility ID certification number, direct the applicant to establish a REC account with PJM GATS within 30 days of certification, and direct the applicant to notify the commission within 30 days if the information on which the application is based should change. With respect to item number 4, I move that we accept the tariff revisions for filing and direct the company to file clean copies of the revised tariff pages with an effective date of September 1st, 2020. Mr. Secretary, just to clarify, that effective date is indeed September 1st, 2020 on item number 4.
That reflects, I believe it's 2021. I apologize.
Oh, okay. Thank you. As noted, 2021. And with respect to item number 5, I move that we note the filing. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton. Commissioner O'Donnell.
All right.
And Commissioner Richard. I vote aye. The motions are approved. Mr. Secretary, the administrative agenda, please.
Excuse me. I apologize. This is Olivia Kirkendall on behalf of staff. For item number 4, it is 2020.
It is. Oh, thank you, Ms. Kirkendall. I should have called you up there. Thank you for clarifying. So just for the record, I would say we should take the vote again on item number 4. I move that we accept the tariff revisions filed by IDT America Corporation for filing and direct the company to file clean copies of the revised tariff pages with an effective date of September 1st, 2020.
I got a question.
Commissioner O'Donnell has a question before we take the vote.
Ms. Kirkendall, why is it so backdated? It's over a year, 14 months.
Yes, that was due to issues with compliance with the State Department of Assessments and Taxation. This was sort of an ongoing issue with this company that we went back and forth with, which was not entirely the company's fault. It was sort of to do with some working from home issues with the state and things like that, which alluded to this extended time period of IDT not being in compliance with SSTAT.
Okay. All right. Thank you for that. Sorry, Mr. Chairman, I didn't mean to interrupt.
No, thank you, Ms. Kirkendall. Good to see you. The motion stands. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton. Commissioner O'Donnell.
Aye.
Commissioner Richard.
Aye.
I vote aye. The motion is approved. Mr. Secretary, the administrative agenda.
Mr. Chairman, item number 6 on the administrative agenda is a request from Standard Solar Inc. For waivers of operational deadlines for its Meadowmark and Viceroy community solar projects. On this item for staff, we have Annette Garofalo and Michael Dean, and for the company, David Buegelmans, George Wogelmuth, William Martinez, and Justin Kasunik.
Thank you. Ms. Garofalo, good morning.
Good morning, Mr. Chairman, and Commissioners. I apologize. I don't know how to turn that off. I'm on here twice, so I'll be short.
Ms. Garofalo, I heard you may be aware you're on a double mic. Is there a possibility to close one of them?
Try. Let's see. Can you hear me now? No.
Well, we could hear you in stereo. It's a double. Perhaps I'm not sure if the host advisors could turn off one of.
Oh, that'd be great.
Let's see if the host advisors could turn off one of your two mics.
Please try one more time.
Oh, all right, Miss. Thank you for trying, Ms. Hoy. Ms. Garofalo, we lost you entirely in terms of sound. We hear nothing now. So if the host advisors could unmute Ms. Garofalo, we'll try to figure this out.
Ms. Garofalo, could you unmute yourself and try one more time? We're going to see if we got rid of that feedback.
Yeah, we have our buck sheet recommendation. Are we okay with just going back?
Ms. Garofalo, we sent you a request if you could please try unmuting your mic one more time.
Right. Can you hear me now? No, this is.
Ms. Garofalo, it appears that you are logged in 3 times. Is there a way that you can turn off speakers on 1 or 2 of the devices you are using?
Okay. So I think I think that worked.
Ms. Garofalo, that is correct. That did work. Give us just a moment.
Okay.
There we go. Thank you to the team. Thank you for your patience. Ms. Garofalo, you may proceed when you're ready.
Thank you, Your Honor. Good morning, Your Honor, Commissioners. Thanks for your patience. Standard Solar is requesting that the Commission waive COMAR 20-620304C as it applies to its community solar energy generating stations, Metalmark and Viceroy. The extension is 4 months in addition to the time period that it has currently used, which did include a time period of which gave it an additional, I think, 2 years. And that during this time. So it's a short extension, and the company has explained the reasons it needs the extensions, and staff agrees that the extensions should be granted. The only issue here that staff wants to bring before the commission and to give notice basically to future applicants is that because Standard Solar purchased these CGISs, they really already had problems. Those problems were known, and we would like to just put the other companies on notice that in the future staff wouldn't necessarily, and I say staff since in general I'm the one who writes these up in the first place, although of course many other people approve them. In the future, these should not have problems at the point at which they're purchased. That could be considered a policy issue by the commission. And we would ask that the commission direct the utilities to be aware that they have an obligation, and I think the utilities do this, but to take the projects that are uncompleted out of the queue at the end of their due date. So it's in a way, this is a simple application. I'm trying to shorten it because I spent so much of your time being on double volume. But we would ask that you approve the applications, but direct the utilities not to be aware and to continue to take CGIS applicants out of the queue if they have not met the time period. But also we would like to note, and I'm happy to discuss it if you want, that we think that it doesn't necessarily, even though every case is different, we don't think it necessarily qualifies as unforeseen consequences if a company purchases a CGIS in process that has had unforeseen consequences. And those have been most of what have come before you since the regulations have been revised.
Thank you, Ms. Garofalo. Good morning, Mr. Buegelmans.
Morning, Mr. Chairman, Commissioners. David Buegelmans on behalf of Standard Solar. I'm also joined today by George Wolgemuth, William Martinez, and Justin Kasanick from Standard Solar. I don't have too much to add to staff's buck sheet, but I would like to provide a brief update on the status of the projects and address staff's position with respect to the acquisition. Well, these projects have experienced delays in supply chain issues. I'm happy to report that they have made significant progress and are now stage 4 construction. Standard Solar now expects to receive final site development and grading permits from Howard County this week, with construction mobilization occurring on December 10th. Solar modules, switchboards, and transformers have been ordered and are now staged at a local warehouse. while switchgear, piles, and racking are still not delivered, but are expected to be delivered by mid-December. So both projects are now ready to mobilize for construction, but still require these 4 additional months to reach commercial operations, which is why the extensions have been requested. With respect to the acquisition of the projects from One Energy, staff notes in its buck sheet that that is the basis of the request, which isn't correct. The request does recount the development efforts of One Energy and then Standard Solar to provide the full picture of why the projects are where they are. But after the projects were acquired, that's when the supply chain issues hit, which is an issue that we've seen for some of these other projects and why these extensions are necessary. It is fairly standard in the industry for projects to be acquired prior to construction by a company like Standard Solar. So there's nothing out of the ordinary. But I want to make clear that the acquisition in and of itself is not the reason why we're here today. With that, I won't go into too much more detail, but we do have the full Standard Solar team. We're happy to answer any questions. Thank you for your consideration.
Thank you, Mr. Buegelmans. Questions from the commissioners, starting with Commissioner O'Donnell.
Thank you, Mr. Chairman. Good morning, Mr. Buegelmans.
Morning.
You don't anticipate any winter construction delays in the frozen tundra of the moderate temperature of the mid-Atlantic state of Maryland?
I see some folks from Standard Solar potentially nodding. So I don't know specifically with respect to these projects, but I can tell you that the basis for this extension was really the delays with receiving project equipment. I mean, even to this day, they're still waiting for the delivery of essential project equipment that's required to finish construction. So I think it's possible, and I know we've talked about this in the past, but that's not the basis of this request here.
Yeah, well, I asked that question because we've heard the frozen earth theory before for some of these delays, and I want to make sure that I'm going on the record not to be in favor of that and won't be very inclined in the future should I hear that. So I just wanted to ask that question. But I have a question of staff. 2 questions of staff. Ms. Garofalo, you're asking us to remind the utilities participating in the pilot of their responsibility to remove the CSEGS projects if they go beyond their regulatory deadlines from the queue. How do you propose that we do that? We send them a letter?
Well, I think I was imagining it would just be a sentence in whatever order you issue with regard to Standard Solar.
Well, that doesn't notify the utilities. I guess I'm confused on what you're suggesting here.
Well, I guess I am suggesting 2 things, which are to put people on notice. I don't, and I will say that I'm not accusing any utility of keeping the projects that are uncompleted in an overdue time on the queue. So if you feel that's not appropriate, that would be even consistent with maybe not my recommendation, but with what I had in there. The real problem, I believe, is, despite what Mr. Buegelman said, is that he may have an additional reason, but he, I think, has many permits that are not done, and they're not done because of some things that happened in the past. And if they are done, they were recently completed, because I did ask him about this recently. So I'm trying to kind of unwrap what's going on here with the delays, because what we are witnessing is there are a few companies who have many permits, and those companies are growing, are becoming more of the landscape of community solar in Maryland. That may not be bad, it may not be good, but it may not be something that we want necessarily to encourage going forward. As it appears that at the end of the 3-year mark, a number of companies just kind of left the state or left this business or were bought out.
Hang on, you're going pretty far from where I was trying to get to.
Okay, sorry.
So, I'm not talking about the appropriateness of your recommendation to remind the utilities. I'm talking about the logistics of that. How do we accomplish that in your mind?
Well,
Put it on the news ticker over here on Charles Street or what?
it is in the regulations. When I wrote those words, I envisioned a sentence in the letter that went to Standard Solar. And I think the utilities would be aware that you had noted that. However, I'd be happy to withdraw.
I'm not sure the utilities, they may get it, or they may not.
I'd be happy to withdraw that portion of our recommendation.
I'm not suggesting it's inappropriate. I'm just trying to figure out how we do that, how we remind the utilities of their obligations. They have an inherent obligation to follow the rules, right?
Yes, if you wanted to do that formally, you would have to do that in a letter addressed to each separate utility.
So let me talk to you about your analysis. Your buck sheet says Standard Solar may be said to have met its burden of showing good cause. Boy, that's loaded with a lot of malleable words. May be said to have met its burden of showing good cause. What do you mean by that?
Standard Solar, it's clear from Mr. Buegelmans' application that Standard Solar had a lot of problems early on, and and they persist to this date. It's partly a result, I believe, of where the Standard Solar applications are being built. That this is an area where apparently there was a single administrative law judge who heard all zoning applications of this type. That spot was empty for something like, Mr. Buegelmans can correct me if I'm wrong, but something on the order of 10 months. Obviously, there was a pileup of applications and other work for his successor. This put everyone behind the 8 ball in terms of getting the stage 1 of the work done for what needed to be done by in order to move on to the more, I use this, I'll call it more minor issues, but these are the many permits that someone wanting to build a community solar.
So did they meet their burden or not, is my question, because you say may be said to have met its burden.
Okay,
Meet their
yes,
burden or not?
they do meet their burden, and staff does recommend that this be granted. And to the extent it came off being coy, I didn't mean it to be coy, but I meant it to lead into the fact that staff has recommended a number of times that applicants who have bought projects in trouble have then come in and said, we need more time. They do need more time, but probably it was clear when they bought it that they needed more time. This looked like perhaps I don't know what goes on behind the curtain. Maybe this was looked like a good business deal. Maybe they're just wanting to do a lot of community solar in the Maryland area. And for that reason, they purchased these things which were available, and eventually everything will work out.
Well, Mr. Buegelman says that the acquisition of these companies is not the reason for the delay, and you seem to be intimating that it is.
Well, you know, it's like when there's a problem, there's really always a lot of places to lay blame. I think if he had no supply chain problems, which I think is what he said he had, but now he thinks those have been solved, he still would have had the permitting problems at the time he filed this. So he's asking for 4 more months. And I think that's reasonable, especially in light of the fact that the commission has granted several, I don't know exactly how many, but I'd say at least 6 applicants who've asked for more time under similar circumstances. They've purchased projects.
Yeah, this is a perplexing item to me in this analysis because staff knows that with regard to future requests for waiver, it will not consider acquisition of a project that has experienced unforeseen delays as the grounds for waiver. So this one you do, any other ones coming in the door, you won't. I'm perplexed by that. Why is that? Why
Well,
this one and not the rest that may
every
follow?
project is different. It's always possible that there would be something in the future that would make a difference. But what we have had coming in with some regularity are projects that have been bought. They have been approved. It was just, I think the community is pretty close. They speak to each other anyway about this kind of news. I just wanted to get the news out to them that probably that I would not necessarily, that they should think about it before they purchase these projects that are about to be abandoned.
I agree with that. I think the acquiring company has the obligations to meet the requirements of the person that, or the entity that sold them the interest. And this project has been extended significantly already. These projects have been extended significantly already by operation of law, regulation, and otherwise. And I'm not going to be supporting a future extension of this, and I'm not sure what role the acquisition plays or not. It seems to be in play, not in play. This is not clear. I haven't heard a good reason to extend these, and I'm not going to be voting for it. Thank you, Mr. Chairman.
Thank you. Additional questions of staff or the applicant? Hearing none, I would move that we grant the waivers requested by Standard Solar Incorporated. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton. Commissioner O'Donnell.
Nay.
Commissioner Richard.
Aye.
I vote aye. On a vote of 4-1, the motion is approved. Mr. Secretary.
Mr. Chairman, item number 7 consists of revised tariff pages from Sandpiper Energy, Inc., incorporating the annual adjustment to delivery service rates in compliance with order number 87857 issued in case numbers 9410 and amended by case number 9473. On this item for the staff, we have Benjamin Baker and Kenneth Albert. For the company, Brian Quinn, Mary Kozel, and Matt Everingham.
Thank you. And if representatives from the company could come on to video, we'll start with staff. Good morning.
Good morning, Chairman and Commissioners. Benjamin Baker on behalf of staff. On November 1st, 2021, Sandpiper filed revised tariff pages incorporating the annual adjustment to delivery service rates in compliance with order number 87857 in case number 9410 and as amended in case number 9473, the Tax Cut and Job Acts case. The reduction in revenue and therefore customer rates was driven by a settlement agreement in 2006 that was further modified due to the Tax Cut and Job Acts, where the company would reduce rates each year to reflect their ongoing effort to convert their system from propane to natural gas. The company is required by settlement to file a base rate case after 6 years and once it has converted 80% of its customers to natural gas. To date, the company has converted approximately 90% of its customers and is entering the 6th year of the settlement agreement. Staff recommends the Commission accept the tariff for filing with an effective date of December 1st, 2021, and we are available for questions.
Thank you. Good morning, Mr. Quinn.
Good morning, Mr. Chairman. Still here. It's good to see everybody. Yes, we agree with staff's recommendation. Just one point of clarification: the settlement said 80. We have to file a rate case at the later of conversion of 80% of the customers or 6 years. So that's where we're at. It's going to be 6 years. So the rate case for Sandpiper will be filed late next year, 2022. Other than that, we're here to answer any questions you may have.
Thank you, Mr. Quinn. Good to see you. I do have one question, and it doesn't pertain directly to the application before us, but as the parties are aware, back on October 1st, a new state law went into effect that modified Section 2113 of the Public Utilities Article, which now requires the commission to evaluate climate and labor statutes. I note that you've converted a large number to over 10,000 customers from propane to natural gas. I guess this question is for either staff or for the company. Do we have any sense of whether a conversion is better in terms of environmental aspects or in terms of emissions based on the structure, chemical composition of natural gas versus propane? Mr. Quinn, perhaps you'll start.
Happy to, Your Honor. And I have Matt Evergnam and Marie Kozel from the company to back me up when I say anything that's incorrect. But yeah, well, on balance, the EIA reports that burning natural gas on average releases less CO2 emissions than burning propane, and less by 16%, approximately. So by converting these systems these customers from propane to natural gas, we're actually moving in the right direction on CO2 emissions. There's other incidental benefits also from the conversion that I could talk about, or Matt, you could talk about if you'd like. But the main answer to your question, and in response to the statutory criteria, yes, this improves CO2 emissions by getting dirtier fuels like propane off the grid and replacing them with natural gas.
Thank you, Mr. Quinn. That is helpful. Does the staff have anything else to add on that question?
Yes. So we're in terms of what the data cited by the company, yes, we've looked through that. That makes sense. And on a BTU basis, looking at the EPA's data, we were seeing that as you burn natural gas versus propane, based on that data, we're seeing that it would be lower emissions. The couple things that were unknown talking to our experts and why we weren't going to say it was 100% guaranteed was we don't know the efficiency gains or losses of the equipment that the company's been replacing. If everything's replaced on a one-to-one basis, then theoretically, based on the math from EPA, yes, it would be a decrease, but we also know the company has to replace units wholesale in some cases, and we just don't know what those efficiency gains or losses are. And the other issue when we were discussing was, we know when natural gas leaks, that it releases methane into the air, which is very carbon intensive and is a problem. And we weren't able, as of today, to figure out what the equivalent, I guess, negative benefit to the environment was if propane is released through incidental leaks. But that was just us looking at it, and so those are some side items that we just wanted to make sure you were aware of.
I appreciate that, the research and the caveats there as well. I learned something with respect to the statistic, 16% cleaner with natural gas. So I appreciate both those responses. That's all I had. Commissioner O'Donnell.
Just a follow-up to staff's presentation, because I was already thinking about the leakage. Does the company have any information as to the relative impact of the two fuel sources, propane or natural gas, with respect to uncombusted leakage? Do you know? Does anybody know what that relative impact is?
This is Matt Emmergan for the company. Commissioner O'Donnell, I do not specifically know the impact on that. What I can say is that I do know that the Sandpiper system has no bare steel, no cast iron. It's everything's been replaced with more modern piping, so I know we would have lower leakage rates. But specifically to your question there, the comparison on leakage rates on natural gas versus the truck fuel burned to deliver propane, those type of delivery comparisons that you might have emissions from on both sides. The company does not have that data.
Yeah, it's not the leakage rate that I'm asking about. It's the relative impact of the gas itself on the environment. Two different gaseous compounds.
Methane versus propane, Commissioner O'Donnell, is that what you're asking?
Natural gas versus propane, yes.
Yeah.
Do not have a specific answer on that, Commissioner O'Donnell.
Fair enough.
We could research further.
That's an adequate response for me always. If you don't know, just tell me that. That's okay. All right. Thank you, Mr. Chairman.
Thank you. Additional questions? Commissioner Richard.
Thank you. Probably for staff, just going along with the question that the chairman asked about our new requirement. I'm interested to know, as you're looking, particularly with Pocomoke City, my understanding from the information provided that there are over 500 customers that still have not been converted. So when we're looking at this fund that is created to provide the actual household conversion, do households have an opportunity to also consider electrification, or is this just for conversion to gas?
Right. I do not. Let me answer your question in two parts. And I did mean to mention in my presentation that we also have not done nothing in this situation to consider if what would have happened had the customer chosen electrification over gas or propane. I don't know when the company is going to customers, if they're mentioning the option to electrify. I know that when I looked through their material last night over what when they go to customers to discuss, or at least on their website, they have information that says what they will help pay for and will not help pay for in their conversions, and that the customer does have the option to deny the conversion, in which case the company would help set them up with a propane provider. But I did not see anything about electrification on their website. And if the company has any further information about if they give customers information about electrification, I would be curious to know. I had not asked them that question.
Mr. Evernham can back me up, but Ben essentially got it right, Commissioner. The customers are free to convert or not to convert and choose what any appliances they want. So whether or not we're proactively encouraging them to electrify, I don't know the answer to that. I don't know if Matt can back us up, but the customers are free to choose.
Okay, and
right, I would agree with Mr. Quinn. The customers are free to choose. If they don't want to convert to natural gas, they could find a propane provider. They could also choose to fully electrify. So the customer has the option of which fuel source they would choose to utilize.
Okay, and do they get the benefit of this fund they're all paying into to help with the conversion, just as they are receiving the assistance with the gas or the natural gas conversion?
The fund is specifically for natural gas to propane conversion. It was never set up for conversion to other fuel sources.
That's in the order.
I'm sorry, say it again.
That's in the order,
Okay.
Commissioner Richard, the criteria for the fund.
Okay. Well, I would just observe that given the change in the law and the things that have evolved with our policies in the state, we may want to rethink that a little bit, because again, if we have still over 500 customers in Pocomoke City that have not made the conversion, they may want to be more in compliance with the direction the state's going on environmental policies. So anyway, thank you. Thank you, Mr. Chairman.
Seeing no additional questions, I would move that we accept the tariff for filing with an effective date of December 1st, 2021. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Mr. Chairman, item number 9, the final item today, it consists of tariff revisions from Baltimore Gas and Electric Company, removing the prepaid pilot from its gas and electric.
Yeah, Mr. Secretary, did we skip over item 8?
I'm sorry, we sure did. I'm sorry, Mr. Chairman. Consistent
Right.
with the rest of the day today. Item number 8, it consists of revised tariff pages from Sandpiper Energy Inc. to update its system improvement rate to be effective from December 1st, 2021 through November 30th, 2022. On this item, we have Ben Baker and Peter Wilson for staff. For the company, Brian Quinn, Mary Kozel, and Matt Evernham.
Thank you. We'll begin with staff.
Thank you. Good morning again, Commissioner and Chairman, or Chairman and Commissioner Benjamin Baker on behalf of staff. On November 1st, 2021, Sandpiper filed revised tariff pages to update its SIR to be effective December 1st, 2021 through November 30th, 2022. The SIR is designed to recover costs associated with bare steel pipeline replacements from a 2003 order, the company's conversion of its propane distribution facilities to natural gas facilities, and the conversion of customer-owned behind-meter piping and equipment associated with the company's propane conversions. The SIR consists of 2 surcharges, a universal surcharge for all customers and a surcharge only for Ocean City residents, and is based on forecasts and associated true-ups. In the instant filing, the company proposes to decrease the current SIR for all customers and the SIR for Ocean City residents, which is driven largely by overcollections of revenue from the last year. The large overcollection was driven by a large variance in the company's billing projections for Ocean City. Typically, any overcollection is refunded through the universal portion of the surcharge, which is collected from both Ocean City and non-Ocean City residents, and does not typically flow through the Ocean City specific surcharge. In this instant filing, staff is proposing that the overcollection associated with the Ocean City surcharge be returned through that surcharge instead of the universal surcharge, since customers in the Ocean City have predominantly paid that overcollection in the last year. So therefore, staff recommends the commission direct the company to file clean pages reflecting the revisions proposed by staff with an effective date of December 1st, 2021. Thank you, and we are available.
Thank you, Mr. Baker. Mr. Quinn, anything to add?
No, thank you, Mr. Chairman. We will be prepared to, we agree with staff's buck sheet, and we'll be prepared to file the revised tariff pages today or as soon as possible, pending approval.
Thank you. Do commissioners have questions? Commissioner O'Donnell.
Mr. Baker, you said a large overcollection. Sorry if I missed it, but how large? What are the total overcollection?
So $500,000, let me pull up my buck sheet to give you the exact numbers. I have a chart in there, but I believe it is about $500,000 comes from the overcollection, and I would say about 80+% of that was coming from Ocean City billing determinants. And so we're not requesting to put the entire refund through the Ocean City surcharge, but just the portion associated with the surcharge specific to Ocean City. And the variance in the forecast was 30% for only Ocean City and was 3% for the remainder of the system. So it was pretty obvious it came out of the Ocean City customers' pocketbooks in this case.
So, Mr. Quinn, why such a large overcollection again? And does that get returned to the ratepayers with the equivalent of a return on their overcollection?
Thanks, Commissioner O'Donnell. I'm going to let Mr. Evernham answer that question, but just a quick history lesson. The Ocean City surcharge was asked for by Ocean City. So it wasn't our idea.
They didn't ask you to overcharge them.
No, but just for some context, in case y'all were wondering what it's there for, they wanted us to coordinate better with them opening up their streets, and we work very well and closely with them. So just wanted to give you a history lesson to the extent that it was necessary. But Matt, you want to explain them?
Yeah, absolutely. Yes, Commissioner. So the reason that we saw the increase in the Ocean City overcollection was really due to the nature of Ocean City being a tourism destination and the impacts of COVID. When we filed last year in late 2020 for projected volumes for the SIR, it was based on the previous year's usage, which had the 2020 summer down here in Ocean City, which I'm familiar with. I live a mile away from the line, which was significantly decreased because we did not have hotel occupancy, didn't have people going to restaurants, but we didn't know what 2021 would look like. And so those billing volumes were utilized off the previous years, which is always our practice. Fortunately for Ocean City down here, we did see a significant uptick in tourism from the previous year to 2021. Far higher increased hotel occupancy, restaurant usage, and that's really what drives all of Ocean City's volumes. And so that's the reason for the overcollection, was because of the significant increase in volumes in 2021 versus 2020, and 2020 is what we had to base our budget off of. To the second part of your question, the mechanics, the approved mechanics within the SIR do not have a interest or carrying charge in any over or under collection.
I'm not sure that seems equitable to me, but neither here nor there. It's not part of it. Thank you, Mr. Chairman.
Thank you.
I was just going to note that I got 7 and 8 combined, and so I was really referring to, with my comments and questions, for the assistant improvement.
The Pocomoke.
Pocomoke and Snow Hill.
I suspect Mr. Quinn nodding had figured that out early. Yes.
I understood you, Commissioner Richard.
Thank you.
Thank you. This is a longer than average AM, and the items are bleeding together. Let me call a vote on item number 8, that we direct Sandpiper Energy Incorporated to file clean copies of the tariff pages reflecting revisions proposed by staff and its comments dated November 24th, 2021, with an effective date of December 1st, 2021. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton, Commissioner O'Donnell,
Aye.
and Commissioner Richard.
Aye.
I vote aye. The motion is approved. The final item, Mr. Secretary.
Mr. Chairman, item number 9 consists of tariff revisions from Baltimore Gas and Electric Company, removing the prepaid pilot from its tariffs. On this item, we have David Hoppick and Annette Garofalo for staff, and for the company, Jessica Raba, David Kahn, and John Frame.
Good morning, Chairman and Commissioners. David Hoppick on behalf of staff. In compliance with order number 89961 in case number 9453, Baltimore Gas and Electric Company has made a filing that removes the prepaid pilot riders from its gas and electric distribution tariffs. In its filing, BGE also states that remaining prepaid customers were all transferred to post-pay service as of November 8th, 2021. BGE is now in compliance with order number 89961. Staff recommends that the Commission accept the proposed tariff revisions. Thank you.
Thank you. Does the company have any response or any additional information to add?
Good morning, Chairman and Commissioners. Jessica Raba on behalf of BGE. We have nothing to add. Thanks to staff. We're just here for any questions.
Thank you, Ms. Raba. Do commissioners have questions? Seeing none, I would move that we accept the tariff revisions for filing with an effective date of November 8th, 2021. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton. Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved. Thank you. With nothing else on today's docket, this meeting is now adjourned.